today, what we're trying to do and what we hope can provide some assistance to you is talking a little bit about when something that might be happening for you as a federal employee may rise to the level of wanting to speak to an attorney, and why there may be some benefits to doing so, what are some of the common areas that you might want to pursue, and what you can ultimately gain out of the process. So let's get started. So what do we hope to accomplish here during this webinar? Number one, we want to talk a little bit about what it means and what's going to happen when you have a consultation. A consultation can be on a number of different issues, and we want you to kind of understand how you can best prepare yourself for what's going to happen and what you can expect from the attorney during the consultation. What's important too, and what we hope to discuss a little bit, is about how you should prepare yourself in preparing for the consultation and what you should be focusing on depending on what obviously your underlying issue is. And we're going to give you some tips and some guidelines and guidance as to what things you should potentially prepare for so that you can make the consultation most effective. Another area that we're going to talk about is the importance of timing when you want to talk to an attorney and obviously potentially want to hire attorneys. Many of the federal employment issues that we will discuss today, and many issues in general, often have an expiration date, or at least timing can be very essential. So we're going to talk about the benefit of not waiting until the last minute to either speak to or hire an attorney. And then lastly, and sort of in general throughout the process, we're going to talk a little bit about what the benefits are of having a consultation and ultimately potentially hiring an attorney to assist you with your federal employment issue. So let's jump in. So what should you expect to have occur during a consultation? For the most part, obviously your issues are going to differ, but you should be prepared to have the attorney review the facts of your case with you. And with that, you should probably prepare yourself to be able to, explain what exactly you're having an issue with. One of the benefits of having speaking to an attorney is not just telling your story and having somebody, agree and be a champion for you, but also getting the perspective from the other side, having an attorney identify what some of the potential issues or defenses that the other side might have, here obviously the government, regarding your matter. Another area that can occur during a consultation is if you have specific documents, having those documents reviewed by the attorney and going over them together to understand the nature of what is being asked of you, the nature of what you might have to provide in response, and the importance of that document, and then how it potentially develops the rest of your strategy in your case moving forward. Obviously, depending on what your case is about, there are sometimes specific procedural steps that you should be prepared to discuss or even be informed about during the consultation. And in a little bit, we're going to talk about some specific legal issues, but during a consultation, you should expect to be informed of what steps will take place in the life cycle of your case and what some of the possible outcomes or next steps may be. With that, there can be a discussion of the strengths and weaknesses that may exist in your claim. Also, regardless of whether or not your issue is ultimately going to result in you retaining the law firm and the attorney that you're talking to, you also can receive just advice in general about best practices and next steps, even if you decide that you're not going to retain the firm. Let's go to the next slide. So let's talk a little bit about some specific areas that are very common in the consultation process, where we see repeatedly people having these issues. So the first and probably most common area that people call in about are issues related to federal employment EEO cases. So what does that mean? Why would you potentially be having an EEO issue, or why would you have an issue that could fit as an EEO issue? Well, When you are filing an EEO complaint, what you are alleging is that you are either being treated unfairly on the job because of your race, your color, your religion, your sex, to include pregnancy, gender identity, sexual orientation, national origin, disability, age, over 40 and obviously older, or genetic information, or that you're being harassed at work for any of those reasons, or that you're being treated unfairly because you complained about job discrimination or assisted in the job discrimination complaint of somebody else or their, lawsuit or action. So what that means is that, in essence, retaliation for, helping in somebody else's complaint. When you first have one of these issues, you are ultimately going to be filing what they call an informal complaint. The informal complaint, the importance that you need to take away from this is that time is essential. If something happens a year ago, not that it isn't horrible, you will probably not be able to file an EEO complaint, and there may be no remedy for that issue. Most federal employees, most agencies require that you bring your complaint within 45 days of the incident. So that's pretty important in what we're discussing here today, and why you would want to have a consultation and potentially talk to an attorney pretty early on after that incident, because your time is ticking. Now, during the informal complaint process, there are generally two different pathways. You can either engage in what they call traditional counseling, which is where the EEO counselor informally investigates your complaint and takes your issues to management and sort of works as a conduit between you, but you don't really have any interaction directly with the agency representatives, as opposed to mediation or ADR, when you would have the opportunity to directly express what your issues are and have a meeting where there's usually a neutral party who serves as the mediator, who would discuss those issues before the body, and you would have the opportunity to communicate directly. Now, if you have an attorney, obviously your attorney can help you actually file that complaint, draft it, try and perfect it, and then be in the role of negotiator so that you're not having to try and do that on your own. Now, with the informal complaint, not every complaint resolves during that level. And what happens is, and generally you're talking about anywhere from 30 to 90 days. That's how long the informal complaint process will last. If it doesn't resolve during that time frame, you're going to get what's called a notice of right to file a formal complaint. And this is another area where it can be very critical when it comes to timing, because you only have 15 days from the date that you receive that notice of right to file to then file it and move forward, or no matter how egregious the conduct might be, your complaint may be expired at that point for not doing so. Now, during the formal complaint, you're going to ultimately be engaging in what's called a formal investigation. So it's unlike the sort of informal thing that goes on during the informal complaint. You're actually going to be doing an affidavit with an investigator. Management officials are going to be doing the same. You're going to have the opportunity to review those, which is, again, another important time when you may need an attorney to help you not only prepare your own statements, but also review the statements of the management officials to make sure that the investigation is as beneficial as possible. Now, that investigation can take up to 180 days and sometimes even longer, but at the 180-day mark, if you have received the report of investigation, what they call the ROI, or any time during that complaint process, if you receive the report of investigation, you are going to be given the opportunity to make some elections. The report of investigation isn't just going to say, yes, we find in your favor. You then have the ability to select how you want that decision to come. Do you want the agency to review and make what they call a final agency determination, or a FAD? Or are you going to elect and say that you want to go to the EEOC and have a hearing before an administrative judge? That's something that you can talk to an attorney about to determine what would be your best course of action. Would this be something that you would want a final agency determination on? Is this something that you would want to go before an administrative judge? What are the pros and cons? There's also another option at this phase. You can also opt out of the EEO process and go to federal court, and you would obviously want to talk about the pros and cons of doing that. Now, if you ultimately elect to go to a hearing, there is usually somewhat of a delay. We're dealing, unfortunately, with the government and, bureaucracy, so things don't always move as fast as we would like them. But once the judge gets assigned, there are going to be some kind of immediate deadlines that happen and some things that you will have to do in terms of responses. There's what they call a preliminary case information that you will have to submit that explains some of the things that have happened up to that point, some of the things that you're seeking in terms of relief, what the parties have done to try and negotiate, and you're required to provide a response. And if you fail to do so, it can lead to the judge deciding to dismiss your case. So it's very important that if you don't understand that and you need help with that, that you would reach out to an attorney and talk about that, because it can ultimately negatively affect your case if you just ignore those things. Now, once the judge is assigned, there's usually what they call an initial conference scheduled, which is going to set some of the timelines that are going to go on for the rest of that case. And the first big timeline tends to be what they call discovery. And that's where you and the agency attorney will exchange information. And there's specifically requirements on how you have to do that. There are time limits associated with it, and often can be very complicated because the agency counsel is often not trying to be helpful. They're not trying to be necessarily the most honest broker in all of these things, and they're not there to look out for your interests. So this is another area where often having counsel can be very beneficial, because you're making sure that somebody is reviewing those matters, preparing your own requests, and making sure that you're getting everything you can out of discovery and that you're not being subjected to anything that you should not have to provide. And like I said before, there are often very strict timelines associated with both initiating discovery, when things have to close, when you have to make sure that you have your submissions completed by, and failure to do that can negatively influence your case, and can, even if you fail to respond to, say, the agency's request, the agency could seek to hold you in even contempt, and that could negatively affect whether the case even moves forward. There are also depositions that can happen during the discovery phase, and that's where you may be called to answer questions by the agency, and that would be recorded with a court reporter. Now, obviously, it can be beneficial to have counsel there to, number one, help you prepare for that, but also to make sure that there's nothing that's going on during that questioning that could negatively affect your case. After that phase, there are sometimes motions that are filed either by you as the claimant or by the agency. The motions that generally come at this phase are motions that would potentially dismiss the case, or on your side potentially be able to win the case without having a hearing. But they have very specific legal requirements and also usually pretty tight deadlines. It's one of the areas that I frequently talk to people about, because it is often very complicated for a lay person, a person who, has not spent their life practicing law, to just sort of jump in and try and figure out how to respond to those, because it's not just being able to recite the facts. You're often going to have to make very significant legal arguments to address what's going on in that case and why maybe it should not be dismissed, or if obviously you're trying to do a motion for summary judgment where you would be successful, why you meet those legal requirements. If the case survives what we call summary judgment, and that's the motion that would be filed at that phase, then you're going to start preparing for the hearing itself, and there's deadlines. And this is not like you see on TV where you just kind of walk into a courtroom on the day of and you just kind of do whatever you want. There's very strict procedural requirements, and you often have to do whatever evidence that you're going to try and present is often going to have to be presented during what they call a pre-hearing submission phase and discussed during the pre-hearing conference. You're not often having the opportunity to pull some sort of surprise document out during these processes. So that's another area where people can often get in trouble when they're trying to do these on their own, because they don't understand, number one, how to put the evidence that would be necessary together to meet the elements, but then also what exactly they're supposed to provide and when they're supposed to provide it. Now, if the kind of worst case scenario happens and your case ultimately is dismissed by the judge and you're unsuccessful as a result of the hearing, that does not mean that your case is dead. There are appeal options. You can appeal to what they call the Office of Federal Operations, or OFO. But that also is another area where there are very strict timelines associated with it. So it's something that you don't want to miss. And again, in these areas, you're often going to be making very hyper-technical legal arguments. So it's another area where having an attorney and talking to an attorney before trying to do that on your own would be beneficial. Next slide, please. So if you're having a consultation on an EEO issue, what are some helpful tips that can make it most effective? Well, one of the big areas is knowing kind of the specific dates. So it can be very beneficial for you to put together a narrative or, a couple paragraphs about what's happened, when it happened, the parties that are involved. Number one, that can be helpful because, as we talked before, timing is very important in these cases, but also it can help you best communicate to the attorney during the consultation so that you're using your time most effectively. Of course, if you've received anything, either, if you're at the EEOC and you've received something from the judge, or you've received, say, that notice of right to file a formal complaint, you would want to provide those documents to the attorney for the, in preparation for the consultation, because it's going to be helpful as opposed to you trying to communicate what you think the deadlines might be, having the attorney, because the attorney has some experience in where to find these things, what these deadlines really mean, what are your requirements as part of that. And it's better to have the attorney actually have the document than you try to have to explain it to them. That's going to make your consultation more effective. And then always, as always, be on time and be ready to discuss the issues. Sometimes people, and obviously it can be through nerves or just not understanding how the consultation is going to go, but people can sometimes not really want to discuss what happened. Well, an attorney really can't help you if they don't know what your issue is and you describe the circumstances, and really should kind of get into the habit of being able to explain, because unfortunately, as this process goes on, the EEO complaint, it's not like you get to write it down once and that's it. You will be frequently asked to discuss what happened, how you believe you were discriminated against, what your harm and injuries may be. And you're going to have to prepare, because if it gets all the way to the point of a hearing, you're going to be one of the primary witnesses. So it's good to practice when you're talking to the attorney and be able to be, direct and concise about what your issues are and what you're seeking help for. Next slide, please. So another area that we see as a frequent consultation topic is areas related to maybe misconduct or proposed disciplinary actions. So there are times, obviously, as an employee that you may be accused of something and there is an investigation, whether it's more formalized through like an Office of Inspector General or even a law enforcement entity, or it can even be, some of your leadership, your boss or your boss's boss, asking you questions about your conduct. Now, for the most part, if the subject matter of the investigation, if what they're accusing you of doing, they don't intend to have any sort of criminal liability associated with it, you are going to have to communicate and participate in that investigation. You are not going to have the right to remain silent if they are asking you about matters that are going to be purely from an employment or administrative process. And that can sometimes trip people up, because people are used to, hey, you're asking something of me that could, influence my job negatively. I don't want to cooperate. But actually, your failure to cooperate can be a basis in and of itself to propose discipline. That doesn't mean, though, you can't communicate with an attorney about what's going on and actually have an attorney help you through the investigation process to make sure you understand what your rights are, know what's going to happen. And really, one of the big benefits can be that as an attorney, we can step in while the investigation is going on to try and negotiate and even try and address maybe some of the evidentiary issues or legal issues to maybe influence whether or not there's going to be any proposed discipline that will follow. So that's where sometimes time, again, can be of the essence, is instead of waiting to see what happens with an investigation, being a little bit more proactive and talking to an attorney and even hiring an attorney can help influence whether or not you face discipline at all. But if you get to the point when and you actually are proposed for discipline, not all hope is lost. You know, just because you are proposed for discipline does not necessarily mean that you will actually have the punishment enforced. And it doesn't mean that there's not opportunities to prevent defenses, extenuation, mitigation. And that's another area that obviously it can be very beneficial to talk to an attorney about, because some of the arguments aren't just you explaining what happened, but it can also be about whether or not the agency, number one, is using evidence that is, you know, considered legally satisfactory, or are they doing the analysis correctly? Is, you know, did they meet all the elements of the allegations that they've laid out? And this, again, is an area where there are very, very tight timelines. In most instances, when you receive a proposed disciplinary action, you are usually talking about that you will be given between 7 and 14 days to respond. And we're talking about calendar days, you know, not business days. So this is not something that you often want to wait around. And we have had situations where people, you know, may also have union representation, and they may go to the union, and the union, you know, kind of puts them off for a while. That is usually a time that you maybe want to look out for yourself a little bit more and not take the word that they'll get to you. Reach out, talk to an attorney, and talk about what your options are early after you get that proposed action, because you may not have the opportunity to really put on the best defense if you wait until the last minute. Now, just because one of these actions happen doesn't mean that you, again, are out of, you know, hope. Depending on the type of disciplinary action, you have certain types of appeals. Now, if you're talking about reprimands, if you're talking about suspensions that are 14 days or less, for the most part, you're often going to either, if you have a collective bargaining agreement and a union, you may have a negotiated grievance procedure where you can file a grievance and potentially go all the way to arbitration. If you're not in that position, for the most part, you're going to be looking at either the administrative grievance process, or it can depend on if you think that there is a motivation that is unlawful in why they did it. Not so much that you disagree with the facts, but you think that the reason behind why they did it may be an EEO issue, or, as we're going to talk about in a little bit, a whistleblower issue. You may have appeals through either the EEO, the OSC, or some other option. But again, another area that it would probably be a good idea to talk to counsel about, because number one, there are going to be time issues related to what your options are, and trying to identify your best path forward. But for things like demotions of a pay grade, removal, those are going to have much different appeals process. You're going to have more what we call due process. For many people, you're going to have the ability to go to what they call the Merit Systems Protection Board. But again, very tight timelines. And once you get there, much like the EEOC, there are going to be, you know, discovery periods. There's going to be pre-hearing submissions. There are going to be all those same things that can often be very complicated for a person who does not handle these on a day-to-day basis. Not to mention the fact of, you know, just having somebody who's advocating for your interests and being able to identify what the best course of action, plan of attack, and legal issues that might be available to you. And same as there's usually areas for even after, say, like the Merit Systems Protection Board, there may be final appeals thereafter, either doing a what they call petition for review to the MSPB, or even sometimes going to federal court thereafter. Next slide, please. So again, like we talked about before, what are some of the things that can make your consultation about a proposed disciplinary action or an investigation most effective. Obviously, if you actually have been proposed for disciplinary action, it is really critical that you send that proposed action to the attorney so the attorney can follow along and identify issues that, number one, you may not have recognized, also to make sure that obviously the timelines are all met, and so that you can best discuss what the issues are. Also, another thing, just like EEO, having a narrative, especially if there's maybe a long history of things that have gone on that led to this, that can be very helpful, not only to share with the attorney for their use, but also to help you focus on, where you want to go during the discussion. Now, when it comes to maybe more specific things related to a proposed disciplinary action, there may be people that that could be beneficial and be witnesses on your behalf. So you would want to think about that, who those people would be, so that you can potentially discuss that with the attorney. Same with what we call comparator situations. So if you're aware of somebody else in your agency who may have been accused of doing the same or a similar thing, and they were disciplined in a different way, that's something that you would want to be prepared to discuss, because that's something that we would probably want to explore for purposes of the answer, because in many disciplinary actions, there's an analysis called the Douglas factor analysis that gets into whether or not the agency is fairly disciplining you, in essence, like a proportional discipline based on not only you personally, but on the actual conduct that they're punishing. And if somebody else did something very similar, but was punished, say, far less harshly, then that may be an issue that we would want to explore, because it may look like there's disparate treatment going on, some unfairness, or some illegalities. And as we said before, always be on time and be prepared to discuss the issues. Next, please. So we talked about this a little bit just a couple minutes ago. Another area that's kind of common in that federal employees do face are potentially what we call OSC complaints, but really what that is when you believe you have a whistleblower or prohibited personnel practice complaint. So this is something that often you really do need to talk to an attorney about, because they're not as intuitive as other things. Prohibited personnel practices, there's several different areas. It can be an actual prohibited personnel practice, can be an EEO issue. Although if you had that type of prohibited personnel practice, you would be filing it with the EEO. But for the most part, if you're talking about maybe somebody is engaging in political activity, maybe somebody is trying to influence whether or not you can compete for a new position at your agency, a promotion opportunity. Maybe there's some nepotism going on. Maybe there's somebody who is being, given favoritism in hiring practices. Maybe somebody is being discriminated against for not like an EEO issue, but maybe something else that doesn't really impact on performance, but is adversely affecting them, or things like, not taking the veteran's preference into consideration, or other veteran issues, and pretty much anything that can influence and be a negative to the merit principles. But then there's these core issues that also can arise when you may have reported something that's either a violation of a rule or a law, that you complained about gross mismanagement, you complained about fraud, waste, abuse, health and safety concerns, and then you feel like you're being treated unfavorably because of that, and or something actually has happened to you where not just a threat, but actually like disciplinary action has been taken, that could lead to a whistleblower or prohibited personnel practice complaint. And with those, that can be potentially a defense if they're trying to take some action against you, or it can be its own complaint to try and then appeal the action that's being taken against you, or otherwise try and change the behavior that's going on, or maybe even seek damages. For many agencies, you have the ability to file with what they call the Office of Special Counsel, the OSC. Some agencies do not have that protection, and that's another area why you would want to talk to an attorney, because, say, for an example, the U.S. Postal Service, you do not have the ability to file a whistleblower reprisal complaint with the OSC. Your remedy would be to file internally with the Office of Inspector General, but that's something that's not necessarily commonly known. So that would be something that you would want to talk to an attorney about so that you could get your best options and, way ahead in strategy, and even have that attorney draft your complaint and help negotiate on your behalf. Now, with those federal employees who have the ability to file with the OSC and they're filing a complaint based on whistleblower reprisal, you have the OSC has the ability to take corrective action, but sometimes they don't. Sometimes they can't come to a resolution, and they can give you what's called an individual right of action. And what that means is it allows you to now go to the Merit Systems Protection Board, where you may not have otherwise been able to go there because your action was not in their jurisdiction. So say you had been suspended for 5 days, you believed that the basis for that separation or suspension was retaliation for, say you had filed a previous complaint, or you had blown the whistle on some violation, and you believe that they were retaliating against you, and that's why you received their suspension. You couldn't appeal that issue directly to the Merit Systems Protection Board because it was not over 14 days. But by going to the OSC, you can get that individual right of action to now be able to go to the Merit Systems Protection Board to now be able to argue that that suspension was retaliatory and have the MSPB decide. Now, there are very strict timelines associated with this. When you get that notice, you generally have between 60 and 65 days to file. So that's something that you would want to talk to an attorney about to make sure that you are protecting all of your rights. Next slide, please. So here's kind of like the catch-all. Obviously, everybody has individual issues, and there can always be benefit to speaking to an attorney, especially if you're not really sure where your issue fits. But here are some other maybe more common topics that we hear. Now, obviously, people can have injuries that either occurred as part of the job or otherwise, and it's now making it so that you don't have the ability to perform your job the way that you need to. And commonly what we call, you can't perform the essential functions of that job, and you can't perform useful and efficient service. Now, if that happens, and your agency can't accommodate you, then you may be seeking to apply for disability retirement. This is an area that, again, can be very beneficial to talk to an attorney, because even though your agency, if you are still with your agency at the time, if you have not already separated, is supposed to help you, unfortunately, they rarely do help you in the sense of, other than providing you with the forms, they do not actually help you fill those forms out. And ultimately, these types of applications are going before OPM, the Office of Personnel Management, and they are very hypercritical. OPM is not looking to just sort of think, okay, yeah, this person's, you could even have 100% VA rating for service-connected disabilities. They are not going to presume or assume that that means that you are unable to perform your job in a useful and efficient way. They are looking very much and critically at the information you provide and making sure that you hit the criteria that is required. And there are several criteria that address the nexus between your condition and the job that you're performing, and how that is inhibiting your ability to perform what I used before, useful and efficient service. Also, timing is going to be an issue. You have to have at least 18 months of credible federal civilian service to be able to apply for disability retirement. The disability also has to have a certain level of permanence. It has to last for at least it's going to expect it to last for at least a year. This can't be sort of a temporary issue. The agency is going to have to certify that they can't accommodate you, and that reassignment to another position that is vacant in your agency of a similar pay grade, similar location is not available. You're also going to have to make sure that if you have already left the job, that you are applying for this within a year of your separation. And you're also going to have to apply for Social Security benefits at the same time. It does not mean you have to be approved for Social Security benefits, but you have to apply. And if you don't do that, that would be a basis for them to deny you. There's also an appeals process associated with this, to include even going all the way to the Merit Systems Protection Board. But again, these are things that you're often going to want to talk to an attorney about, and even potentially hire an attorney to help you actually do these applications, to work with you, your agency, and even your medical providers to make sure that you're in essence dotting all your I's and crossing all your T's. Now, we talked a little bit about grievances a second ago, but there's grievances that are part of a collective bargaining agreement that are what we call negotiated grievances. For the most part, you're going to be talking to your union representative about those, because that is often your exclusive remedy. Sometimes attorneys can get involved in negotiated grievances, but you generally have to have the authorization of the union to allow that to happen. You in essence have to waive your right to the union and get your union to agree to allow an attorney to assist. However, in cases where you do not have a negotiated grievance, most agencies have an administrative grievance process. Now, that they are very strict timelines. Often it's 15 days from whatever the issue you are grieving is. Common topic areas for grievances can be an evaluation. That's probably the most common. It also can be, say, like a letter of reprimand. That's a common area that people grieve. So that's an area that you would want to explore with an attorney to talk about what the process is, the timeline, the pros and cons, the different evidence that you would want to use, trying to, obviously when you're grieving a specific decision, looking at the legal issues that might be most beneficial to make your case most successful. Desk audits, also called reclassification appeals. What that is many people are performing jobs that they may believe that they are ultimately performing duties and have responsibilities that exceed what their current pay grade is or title is. There is an opportunity to try and challenge that. That's an area that you would want to explore with an attorney, because there are different pros and cons to where you go with that complaint. And the timing and obviously the evidence you use. In many instances, we advise people to work through their agency first instead of going directly to OPM, because OPM has a tendency to look at situations and often think that the people not only should not be upgraded, but they should actually be reduced in their pay grade. So it's usually not a great idea to go to them first. Usually a good idea to lay out your case with the agency. If the agency denies you, then OPM, you can appeal to OPM, but now they're looking at the agency decision. They're not necessarily going back and determining whether or not they think that the pay grade you currently have is the right one. Another area that we see a lot is debt issues. And this is obviously focused on the idea of maybe owing a debt to the government, either because you were overpaid, or there was some erroneous issue where they're now saying you received compensation that you shouldn't have. This happens sometimes when people have retired and the government is alleging that they did not do the math correctly and they are now seeking to recover those funds. Debt issues, ideally you would like to try and communicate with an attorney and discuss your options and even potentially start to take action within 30 days of the notice, because that can often prevent them from taking collection efforts while they decide on either your waiver or your dispute. If you wait thereafter, they will often start deducting funds from you while the process is ongoing. And sometimes, as I'm sure you recognize as being government employees, the government does not always move fast. So it can sometimes take months, if not years, for them to resolve this. And you're then having these debits taken out of maybe your pay, or even potentially getting referred to the Treasury for collection efforts. So it's always best to not ignore those and try and get out in front of it, because there are areas to not only dispute, but obviously to seek waiver based on things like hardship, like financial issues. So it's a good idea to talk to an attorney about those things. Next slide, please. So some bad habits that it's probably a good idea to try and avoid. There's attorney-client confidentiality during a consultation. So it's not a good idea to just try and paint your story in the light that's best for you and leave out those details that may either make you look bad or may not be, as we like to call, bad facts. You're not going to get the most you can out of a consultation if you're hiding things from the attorney. And you're also not going to get the best out of representation if you then subsequently retain that attorney if you're not telling them the whole story. We can work to address those things that are bad facts if we know about them, but what is very difficult to do is to have those sprung on us when we're like at the hearing, when now we couldn't have planned for them. It also might have changed the strategy all along. So don't hide things, be open. Nobody's going to then, tattle on you thereafter. Be open and candid. That's where you're going to get your best advice, and it's going to be the most effective consult. Now, in some of these cases, particularly the EEO situation, you could have hundreds, if not thousands of pages of documents. For the consultation, don't send hundreds of documents. The attorney's not going to be able to review them prior to or during the consultation. Try and be more pinpoint with the documents, especially those ones that have like deadlines or things that you're required to respond, because those are going to be the things that you're going to have to focus on during the consultation, because they're going to be the things that require the energy and the action immediately. Ultimately, if you wind up retaining an attorney, we're going to get every document that is necessary, but just not during the consultation, because you're just going to ultimately spend most of your time, sifting through documents, and you're not going to get the best benefit out of the discussion. Also remember, you're calling an attorney not as the opportunity for a cheerleader, right? You want to talk to an attorney because you want to get their perspective. It's one of the reasons that having an attorney can be very beneficial in all of these cases. Is it's very difficult to represent yourself because you know what happened. However, you are now having to convince somebody who is not you, who was not privy to any of these situations. They were not a witness. You're trying to persuade them. Sometimes because you are so within your own perspective, you can't see where there might be issues. It's a good idea to listen to the attorney's perspective, because the attorney is ultimately voicing the same things that opposing counsel might be looking at, and probably the judge as well. So this is the way that we ultimately build the strongest case, is we try to a degree poke holes. It's not in any way trying to be, nasty or uncooperative. We want you to get our perspective because that's why you're calling us. You want to get the attorney's perspective, not just have somebody tell you exactly what you want to hear. Make sense? I think so. Next slide. So, we talked a lot about timing. So having an attorney involved as early as possible is often going to be your, best opportunity for future success. And when as early as possible? Now, obviously, like we talked about, maybe in like the investigation type of case, it may be the second that you get notice that they want to interview you, or just, your boss says something to you about some issue of your time card. You might want to talk to an attorney there so that you have the opportunity to get out in front of things. But obviously, anytime you receive a notice, that is a time that you're going to want to pick up the phone, call an attorney so you can get a perspective on, do I need an attorney? What are the next steps that are going to happen in this? What can the attorney do for me? Or just even what should I be doing for myself? Obviously, when we talk about discrimination, as close to the event as possible, and or as close to the negative consequence. So if something happened and then you received, say, a disciplinary action, you would obviously want to do it as close in time to that disciplinary action, or even, if somebody did something, there was an event where you believe that race or sex or age or disability or religion or prior EEO activity was a contributing factor, it's a good idea to talk to somebody, because as we said, most agencies, there's going to be a 45-day time limit for you to then be able to file. Now, one of the reasons that you want to talk to an attorney too is because mistakes can happen at any time during the process. And if you then talk to an attorney early enough, then it won't matter about those mistakes because you can always have time to correct it. But if you get to the 11th hour and, like, say, for an example, in the disability retirement process, like I told you before, you have to file that within a year of your separation. So if you're filing on the eve of that year, and then you ultimately get denied and you go to the MSPB and appeal and they deny you, you are now not going to be able to refile. You're not going to be able to gather more information and refile because you will be well beyond the year at that point. However, if you filed contemporaneous or even started working on it before you separated, even if the worst case scenario happens and your case is dismissed, you would be able to still go back and do a brand new application because you would not have been over that year time frame. So it's always just a good idea to keep all your options open. So giving yourself enough time allows you to keep those options open. Next slide, please. So why hire an attorney? Why speak to an attorney? So when you are handling, I sort of mentioned this a couple minutes ago, when you are handling your own case, it's not that you don't have the knowledge, it's not that you can't obviously go and research and figure out the different process, but there's a perspective issue in all of these things. Number one, you're going to be negotiating with an agency often to resolve these types of issues. The agency is going to be represented, usually a good idea for you to be represented, but also just from the perspective standpoint, the agency is often going to take you more seriously and be more open to listening to what your issues are if they're not coming directly from what we would call an interested party, you. Not to mention your own perspective. As I was talking to you a couple minutes ago, you know what happened. However, none of the other parties involved necessarily see it the same way or were even party to any of these incidents. So you're then ultimately having to persuade them, and you may not be the best judge of how to persuade them because to you it seems clear because you lived it. We as attorneys, we advocate for you, but we obviously didn't live the circumstances with you. So we can often navigate some of those more concerning areas where others may see, issues with proof. We can figure out the best way to address those where you may miss those issues because you ultimately know what happened, but you may not be able to be best to persuade somebody else on what happened. Also, like I said, there's a process and procedure to a lot of these things. And there are deadlines and there are complex issues that need to be addressed that are not just based on the facts, but are often based on, statutes, regulations, other case law. And if that's not something you deal with on a day-to-day basis, you may have a complete and total command of your facts, and you may believe that your facts ultimately support it, but there's going to have to be a legal analysis of those facts, and that might not be where your efforts are best spent. And that's why having an attorney can often be beneficial, because that's what we do. We're ultimately going to know where the law that would relate to this issue is and how best to communicate that, not only to whoever the deciding official may be, but also in negotiations with the agency. Next slide, please. So obviously, we talked a lot about sort of the general ideas of different areas and why having an attorney would be beneficial. Now, if you have specific issues, this is obviously how you can contact us, and we can discuss your personal issues and discuss the best way ahead, what your potential, area of law that might be at issue, next steps, best practices. And also, it doesn't even have to be a situation where you're ultimately retaining the law firm. Sometimes it's just about getting the way ahead, understanding the process from a perspective that's not either, your employer, somebody who works for your employer, or somebody who obviously doesn't do this on a day-to-day basis, trying to find a way for you to pursue it yourself in the best way possible, but getting that advice from somebody who actually knows, how it works. So I have a question about a constructive discharge. Now, obviously, not knowing the specific circumstances, but that would be something you would probably want to have a consultation about. A constructive discharge, what that means is that you didn't actually get terminated as a result of like a proposed removal and then got removed by the deciding official, but instead circumstances led to you either resigning or retiring, but you're saying it was involuntary, but for some other reason that would not have happened. In those circumstances, the but for situation, that would depend on where you would be potentially filing it. In general, most constructive discharges will ultimately be, if you have an MSPB right, at least the discharge component would ultimately be handled by the MSPB, but there can obviously be issues that it might be an EEO issue, it might be a whistleblower reprisal issue. That's something you would want to obviously talk to an attorney about to determine what your best strategy moving forward would be. But those cases are also usually very complicated because you have to meet a initial hurdle of proving that it in fact should be treated like a discharge and not a voluntary action to either resign or retire. You have to meet an initial evidentiary threshold to say what looks like a voluntary action be treated like one because I was in essence forced to do this. I hope that answers the question. Well, I really appreciate having the time to talk to you all today. Obviously, if you have specific issues, we're always available, and I would be happy to talk to you individually as part of our consultation process to talk about your issues, determine whether or not you would want to work with us. But like I said, probably the key takeaways from all of this is recognizing that these issues are often very complicated. They often have strict timelines associated with them, and having an attorney can often put things in a different perspective for you and also change the perspective of your opponent in ways that you alone may not be able to accomplish. So if you decide that you have an issue that you would like to discuss, please feel free to reach out to us because we would be happy to consult with you and potentially represent you if that was necessary.